All right, let's get into it. When we talk about the 26th Amendment, it's easy to think of it as this settled piece of history, a big win from the past. But that's only half the story. There are really two major fights here. The first was the battle to win the right to vote in the first place, a fight that ended over 50 years ago. But the second one? That's a fight over what that right actually means. And believe it or not, it's happening in our courtrooms as we speak.
You've probably heard this phrase before. It was powerful, simple, and it became the rallying cry for an entire movement. Just think about it, 4 little words that perfectly captured this massive, profound injustice. For decades, it's what young Americans chanted as they were being drafted to go fight, and maybe even die, in wars they had absolutely no say in.
So, let's rewind a bit and set the scene. The idea of lowering the voting age wasn't exactly new, but it really picked up steam when the country was facing these huge, world-changing conflicts. The core argument was just about basic fairness, the fundamental duties of being a citizen.
And you can see how the pressure just builds and builds over the years. It really kicks off in 1942, during World War II, when the draft age gets dropped to 18. A little over a decade later, in 1954, you have President Eisenhower, a former 5-star general, publicly pushing Congress for an amendment. Then, of course, the 1960s and the Vietnam War just pour gasoline on the fire. The real breaking point, though, comes in 1970. The Supreme Court makes this ruling that creates this chaotic dual-age system. Suddenly, 18-year-olds could vote for president, but states could block them from voting for governor. It was an administrative nightmare and just completely unsustainable. Something had to give.
And what happened next is really the second act of this historical story. Faced with this completely confusing and unfair system, the country's response was, well, it was breathtaking. Just incredible speed and unity.
Now, you got to remember, amending the Constitution is not easy. It is designed to be a huge hurdle. You need a 2/3 vote in both the House and the Senate. Then you need 3/4 of all the states, that's 38 states, to get on board and ratify it. The whole process is set up to demand this overwhelming, near-total agreement.
But just look at this. The 26th Amendment basically flew through Congress. In the Senate, it was unanimous, 100%. Every single senator voted yes. And in the House, the vote was 401 to 19. Think about that. It was just this stunning moment of bipartisan unity on a major voting rights issue.
So, the amendment blasts through Congress, and it goes to the states for ratification. And this is where things go from impressive to just flat-out wild. The states ratified it in less than 100 days.
This was, and still is, the fastest ratification of any amendment in U.S. history. And it didn't just squeak by and break the record. It shattered it, cutting the previous record in half. There was no real debate. The country had spoken, loud and clear. 18-year-olds had earned the right to vote, period.
So the first fight won, decisively. But now we have to pivot to that second fight, the one happening today where the promise of the 26th Amendment is being tested in a much more complicated, legally tricky environment.
Okay, so here it is. Section 1 of the 26th Amendment. The two words at the absolute heart of today's legal battles are denied and abridged. Now, denied is pretty simple, right? You can't just pass a law saying the voting age is 19. But abridged, what does that actually mean?
To abridge a right means to curtail it, to diminish it, to chip away at it. The idea is you can't just set the age at 18 and then turn around and put up a bunch of unique hurdles or special burdens that make it way harder for young people to actually cast their vote. And this word, abridged, is where the whole modern fight really kicks off.
So this is the big debate right now in the courts. You've got two competing ideas. On one side, there's this simple rule view, which says the amendment only sets the voting age to 18. That's it, end of story. But on the other side, you have the broader shield view. This says it also protects young people from laws that, even if they don't mention age, put unique burdens on them and make it harder for them to vote. And this clash is the central conflict we see today.
So, what does this modern battlefield actually look like? Well, it's not about one single law. It's really about a whole collection of different election rules and procedures that can have a huge impact on young voters, especially college students.
We're talking about stuff like really strict residency requirements that make it tough for students who live away from home, or voter ID laws that will accept a license to carry a gun but won't accept a student ID card from a major state university, or decisions to get rid of early voting sites on college campuses.
or even rules that make it harder for young people to vote absentee while making it easier for older people. These are the kinds of specific fights happening all over the country.
Which all leads us to this one fundamental question. Is this an abridgment? If a law seems neutral on its face, it doesn't say people under 25 can't vote here, but the actual practical result is that it makes voting a lot harder for a group that's overwhelmingly young, does that violate the 26th Amendment?
As you can probably guess, the future here is very much up in the air. And that's because the courts are having to wrestle with some really, really tough legal questions that, frankly, don't have easy answers. Here are 3 of the biggest roadblocks. First, you've got to prove intent. We know young people tend to vote differently than older people. So, is a law targeting them because they're young, or is it for partisan reasons? That's a super fine line for a court to draw. Second, this idea of privilege versus abridgment. If a state makes it easier for seniors to vote absentee but not for students, are they burdening the students or just giving a special privilege to seniors? And third, this really fascinating argument about a 1971 baseline. Some have argued the amendment only protects the right to vote the way it was in 1971, which was mostly in person on one single day, and that it doesn't apply to modern things like early or mail-in voting.
But here's the kicker. Let's go all the way back to the beginning. This quote is from the original Senate report on the amendment, back in 1971, and it's so revealing. It shows that even then, Congress was thinking about more than just the number 18. They were worried that special burdens, things like forcing students to jump through hoops to get an absentee ballot, would actually dissuade them from voting. And they saw that as going against the whole point of the amendment, which was to encourage young people to participate. And that's what it all boils down to. This is the question that defines the entire modern battle. Was the 26th Amendment just about changing a number from 21 down to 18? Or was its true, deeper purpose to make sure that the political power of an entire generation of voters couldn't be chipped away at or silenced by a bunch of procedural games? The answer to that question is going to shape the youth vote for decades to come.